Folks, that we start at 9, so I would ask that you do log in early. Many of you did, but I'm continuing to have more people, so I apologize. It's going to take a minute to admit people.
Was
she talking to us?
She was talking to everybody.
Please mute your connection. That's the other thing. Mute your connection until your case is called. Thank you. Hodges and Wanzer matter. That's Mr. Anagnostu, and Mr. Zandy's present here in the courtroom. And I had emailed my ruling, so I don't know if we have an order to reflect that.
Not yet, Judge, but I anticipate we will this afternoon.
Okay. All right. Anything further on that?
I couldn't hear what Mr. Zandy said.
Want to repeat yourself?
I just informed that I think we'll have an order over this afternoon.
Okay.
It's reviewed and signed, and there's nothing further from our end.
All right. So with that, I'll go ahead and 562-0. Consider that taken care of. I have Miss Bliss, and do we have Miss Petrie? So we do not.
Then with that, you want to just call that at 11 with my other matter? That's fine.
Okay. The Friedenberg matter. That matter is going to be stricken. Do we have Ms. Gilmore? Yes. Anyone else on that matter? All right.
Your Honor, hear me?
I can hear you now.
Oh, thank you. I did receive signature from Mr. Friedenberg, so we will be entering that order as written.
Okay.
Thank you.
Okay, he is present in the courtroom.
And I did receive email communication from the respondent requesting a setover. It's my understanding he's meeting with Mr. Zandy later this month. The court did indicate a setover to the 23rd. Mr. Zandy's office did request a setover to potentially the 30th. Either works with my schedule. I do have some immediate issues if the court's willing to address that, but I think.
All right. So you're requesting it be set over, is that correct?
Yes, ma'am.
All right. With the 30th work better?
Yes, whatever day.
Okay. If that works, Ms. Gilmore, I'll just set it over to the 30th.
Yes, Your Honor.
All right. As far as any immediate matters, I don't see where that would, unless it's urgent.
Understood. If we need to bring a restraining order, I'll do that.
Yeah.
Okay.
Thank you.
Thank you.
All right. That's it for today. It's set over to the 30th.
Okay, thank you, Your Honor.
I'm here on that matter, Your Honor.
And Mr. Anagnostu. All right, Ms. Gilmore, I think you had a request.
Yes, Your Honor. Very briefly, this matter went to trial in January. Husband was ordered to sell the house by the end of May. He's failed to do so or pay my client. We subsequently brought a motion in order to show cause. We served Mr. Anagnostu's office on the 24th with that motion. On the 26th, his staff indicated that they're willing to accept service. Shortly thereafter, Mr. Anagnostu rescinded that agreement. At this point, my client is on disability and does not have the funds to pay for personal service if possible. We are simply just trying to streamline this matter, and my client has paid exorbitant funds taking this trial and to enforce this order. So we do ask the court order Mr. Anagnostu or his client to accept service of our order to show cause.
Mr. Anagnostu?
Yes, Your Honor, we did not agree to accept service. And I informed counsel the same day that according to the rules, this is a motion for contempt that has to be served personally, and pursuant to CR 6, after 90 days, whether an attorney's still in a case or not, you have to serve the party. That's what the rule specifically indicates. They need to serve basically my former client. I haven't withdrawn, but I haven't had, much contact with Mr. Van Tongeren since this was entered. So he needs to be served. That's what the rules require.
Ms. Gilmore?
And that's why I'm specifically asking for an order allowing it. I do have an email from Mr. Anacos's staff on June 26th saying, apologies, Tammy, I forgot to acknowledge this. We received personal service isn't necessary. I do acknowledge that Mr. Anacost emailed thereafter, but again, my client does not have the financial resources, and a respondent should not be able to hide from an order to show cause because we simply don't have the funds to get him served.
When it's a contempt, it requires personal service. Understand where your client is. At the same time, the rules are set, and so you will have to make personal service.
Okay, understood. Thank you.
Thank you. All right. Who do we have present? We have Mr. Zandy here in the courtroom. Anyone else on that matter?
Andrew Sickles as well.
Go ahead.
And I think, Your Honor, as you're aware, I do represent the moving party petitioner Nicholas Nunez here on my client's motion to have some genetic testing for this very newborn baby established. My client is in the position of basically the unknown at this point, not knowing if he is the father. He has a suspicion to believe he is, I believe, Darian is the baby's name, Darian's father. But pursuant to statute, pursuant to the rules, we need some sort of confirmation on that. My client has, and I think the record is pretty clear, gone above and beyond to try to communicate with Ms. Crease, and that's been essentially somewhat stonewall. I don't know what that means. I don't know what's in between the lines with that, but nonetheless, my client certainly wants to know and has every opportunity to be a dad if in fact this child is his. This is the first step. I have been in contact via email with Ms. Crease, which I certainly appreciate her reaching out to me. Asking about the genetic testing and the process of that, which can sometimes be cumbersome. But at this point, we just need an order that allows the genetic testing to take place, at least between the mother and the presumed father, which again is Andrew Sickles, as I understand, and they can give more insight on this. Mr. Sickles is the named party because I believe they are still technically married. So there's the presumption that plays into this as well. We essentially just need an order allowing my client and the baby to get tested to see if in fact my client does have any rights to parentage. And if in fact he is this child's baby, he wants to be an active participant. And if he's not, he wants his mind to be at ease. So that's kind of where we're at. We are asking the court order the genetic testing, asking that both parties cooperate. The time we do that, I don't anticipate any problems on my client's behalf. And then essentially any cost be split. I do not know, and this is kind of the final summation, if the state is involved in this or is giving any state benefits for the infant, but if so, they would need to have a notice of this and input as well. That again, I expect Ms. Crease to provide some kind of insight as to that issue as well.
So, Ms. Crease, I see your response, and I guess ultimately, are you objecting to the genetic testing getting done?
No, not at all.
Okay. So, can you tell me, do you receive any benefits for the child from the state?
I am personally on SNAP benefits for food. So she was like naturally just added to that because I had to do my review on that since the time that she was born. So
Okay.
yes, she
Whoops, you just muted yourself. You're still muted. There we go.
there. Sorry about that. I was getting a call.
No problem. So unfortunately, I didn't hear everything you said. So,
Yeah, so she's on my thing for family food benefits.
all right. So sounds like they need to also be served.
I will contact the state, get their authorization on the order. I don't anticipate they would object in any way. I have them sign off on that. And if we could do that, set this over 2 weeks to present that order. Ms. Crease, I'll send a copy of that to you for you to sign off on, and we can start the process.
Okay.
All right. All right. And Ms. Crease, if you agree with the order and just sign off on it, then you don't need to appear on July 23rd. That's just simply for presentation of the order.
Okay.
Okay?
Yeah.
All right. That's it for today.
Thank you.
Thank you.
All right. So I have the objections, we do have Ms. Baldwin, we do have Ms. McLean. Ms. Baldwin, I don't know if you've had an opportunity to look at the objections.
I have. So in reviewing the objections, the court specifically said that you weren't making changes to the underlying orders. The total transfer payment did not change a dime. So if the total transfer payment isn't changing, then it doesn't make sense that we would enter a new order of child support. So I don't think that that makes sense in this context. If you look at similarly, I have concerns with their child support worksheet in that they've included taxes, I think, based off of her higher, essentially her actual income that you've ordered, but also plus the spousal. So sort of inflating the taxes based on that higher total gross, but that wouldn't be actually taxed for her because it's not income to her per taxes or per federal law. So spousal support isn't income. So I have concerns with that. I think that my order correctly reflects what Your Honor's intention was essentially, hey, everything is just going to stay the same when we, and then this matter is going to go to trial, and then at trial, the court can then look at it in essentially in reverse and then make changes if it wants to, based on what happened there. And I'll tell the court that the prior order was $1,200 of spousal support and $1,800 of child support. My proposed order is $1,137 of spousal support. So it's actually a slight reduction in spousal and a slight increase in child support, just based on that worksheet. And Ms. McLean's makes it even greater. She makes it to where it's $1,900 in child support and lower in spousal support. So that's sort of the differences in the numbers.
Ms. McLean, anything further?
I would just note that contrary to counsel's argument, my taxes are not run to include spousal support. Those aren't included in the worksheets. I did run the taxes with each of them claiming one child because that's the court's order. And so I ran them both by claiming one child. That's the difference in our federal withholding. I don't know how counsel ran taxes as it relates to her worksheets. That wasn't described, but I provided that in my information for the court. And Mr. Kaufman is a longshoreman. So the ILWU PMA picks up his state industrial insurance, family medical leave, and the long-term care, whereas my client's employer does not. So she's still on the line for L&I, family medical leave, and long-term care insurance, and that's supported by the wage stubs that we had provided with the court. I also do think it's important that we do have an updated child support order, since this is being both the spousal support and the child support are being enforced by WSSR.
All right. So in regard to the child support matter, as far as what has been put forth by Ms. McLean, I think is appropriate for a client. So the support needs to be modified. What's proposed needs to be changed to reflect that. Then ultimately the total amount is going to be the same. That I know.
So I had provided the court with Ms. Baldwin's proposed order that adopted my red line changes. And I signed it dated June 20th. And it doesn't have Ms. Baldwin's signature on it. And then I had also provided my worksheets and my proposed child support order. So you should have all of those as proposed orders.
So then
Should have and do are two different things.
I'm sorry?
Should have and do are two different things.
Oh, okay.
Right. But, and also here's my concern. When we do it this way, then so it's then Ms. McLean gets to object, enter a whole set of orders that then there are none of my objections to. I have objections to her orders.
Yeah.
So then we end up in this very messy situation where like she has her order starting June 4th. That's an odd date. And then that can cause all kinds of problems with WSSR. What are they enforcing? Are they enforcing for 3 days under one order and then the rest of the month under a different order? So we end up with some very odd situations when we do it this way.
That's probably a typo. I think it's supposed to start on June 1st. So if you change in the child support order, you had indicated, so paragraph 11, that should be June 1. Thanks for pointing that out. Sorry about that.
But that's not my only issue. That's one of, I don't have the same opportunity to go through then line by line and lay out my objections.
I don't have her orders, no matter what. So I'm going through what you have, and the only thing that I have is in regard to the child support and the deductions that are proposed by Ms. McLean for her client sound like they are required. And so, so if they're required, then it seems like they should be included as part of the deductions in the child support worksheets. That's all I'm saying.
And that's fine. I'm happy to include those deductions and create an order that reflects those deduction changes.
Okay. So that's one thing. In regard to this idea of that overpayment is to be paid from the liquid assets held in trust, I don't recall specifically ruling that. I don't particularly have a problem with that because I think no matter what, the support needs to get paid. So that will stand. Paragraph 6. I do agree with Ms. McLean on that matter. Paragraph 7.
This was the vehicle that replaced the community vehicle with insurance proceeds after the community vehicle was totaled. So this vehicle technically is arguably partially separate and partially community. So I think it.
And they haven't, that's not established. We would highly dispute that. It's fully separate, purchased after these parties, long after these parties separated. It's fully separate. And so this is a full attempt to just put in a finding of fact into this order to then change the outcome at trial. That's not appropriate.
So in regard to paragraph 7, I'm not going to be removing the post-separation vehicle part of this. And I'm leaving, again, the overpayment language.
Would the court then entertain adding language that characterization is reserved for trial?
That's fine. And then paragraph 10, yes, that should be added. And then renumbering it if it needs to be renumbered.
And just for clarity, on paragraph 6, doesn't paragraph 7 resolve that issue? Because paragraph 6 is specifically that they're to make their own payments, and then paragraph 7 reserves, basically says, and the overpayment, underpayment is reserved. So I don't think that you have to have the language in there twice to make that order effective.
I don't think it hurts to have it in there to make sure it's fully clarified.
Okay, that's fine.
Okay.
Okay, we will redraft that order and submit it.
So can we submit another or provide for another presentation date? My hope is that we'll get it resolved, but I want to have it on the calendar, please.
That's fine. 2 weeks.
Put it on the 16th. That's fine.
Of August.
Oh, you're talking about.
Oh, are you out?
I'm out until the 31st of July, starting this Friday.
Okay,
So
that's
the
fine.
6th or the,
What's your next?
August 20th?
I can do the 20th.
Let me confirm. And that's your next available, Ms. McLean?
I have the 6th available. I'm out. The 13th.
I'm out. The 6th and the 13th, I'm gone.
Okay, I'm available on the 20th. That's fine.
Stevens
Thank you.
and Meter, apologize.
Meter, Your Honor.
Meter.
Morning, Your Honor.
Counsel, go ahead.
And thank you, Your Honor. Of course, where I do represent the respondent, moving party to the motion for you today for contempt, Melissa Young Meter. As we're here today, again, the court's well aware of the history of this case. I'm not going to delve too deep into that. This is one where Mr. Stevens has done essentially everything in his powers to sabotage his relationship with these boys, and he's unfortunately done a very good job at that. Now in a position where we were last in court just after the first of the year, Your Honor heard significant argument from both sides as well as input from the GAL, who ultimately determined that the actions of Mr. Stevens have deteriorated to the point of limiting and restricting contact with both kids. Liam, who's 13, Nathan, who was 17. Court made that very clear. You said for both kids under paragraph number 4 of the order that there would be no contact whatsoever with the children. Here we are, and that order was entered a short time later. It's been in effect since that time. You wanted various evaluations done and treatments done and ordered that Mr. Stevens be compliant with those. And to date, he's done none of that. Or at least we don't have any proof that he's even commenced that or sought the initial steps towards those treatments or those evaluations. And unfortunately, we're in very much the same position today that we were back in January, only there again is supposed to be no contact. I'm not going to get into the other issues with this as far as the child support, as far as the evaluations and treatments. That's outside of what we're here for today. But today is related solely to the issue of the contact with the kids. After we were in court, and again, this is just kind of commonplace, and this was kind of predicted, I think, not only by my client, but the GAL had some concern about this as well, is that Mr. Stevens will do literally anything and everything in his power to try to circumvent the order, to try to essentially weasel his way into conduct that is extremely unbecoming, conduct that is negative, not only for himself, but his relationship with the kids, and basically just trying to circumvent orders. That's what we're here today. Now, so in the spring, during sometime, and this is the social media, as the court is aware, is certainly not my specific cup of tea. My client is much more well-versed in that than I am. But nonetheless, Mr. Stevens, who works in the industry, is very tech savvy, knows that. That's how he spends his career, decides to create these social media spaces, one of which is called Coffee with Jesus. So in order to create this space, he makes this, he invites these different people. There's 2 ways that you can either do this. Number 1 is you send an invitation to your contacts. You say, you're invited to come in, join my Coffee with Jesus space. The other is the individual knows that, finds the space, and then asks to be invited. So if we're looking at this again from a bird's eye view, it's clear to see what happened here. This was created after we were in court. So he either one reached out to the child and said, again, probably through some kind of social media means, seek out Friends with Jesus or Coffee with Jesus and join the group, or just by some pure random circumstance, which seems outside the realm of possibility, Nathan somehow knew about this and asked to join. We don't think that happened. Nonetheless, Nathan starts getting these contacts from his dad through these social media groups, a message directly related to the kids. And in fact, if you look at a couple of those, one states, I miss you more than anything in this world, Nathan and Liam, my boys, you are always in my heart. So this is, I believe, one of those posts on that social media. If he can't have any contact with his kids, why is he posting that other than to apparently look like some kind of a hero or some kind of a victim to his Coffee with Jesus? So clearly he knows what he's doing. Nonetheless, we tried to avoid this. I sent to Mr. Roberts, and again, the communication with Mr. Roberts' office is very good. Sent an email, we've attached that for you saying, hey, here's what I understand is happening. Your client is reaching out through these means to Nathan, and that's outside the court order. Mr. Roberts confirms that, sends me a responsive email, says, okay, we're aware of that. Basically, I'll instruct him to cease. It doesn't. It only ramps back up. So we start getting more messages. Nathan becomes more involved in that, starts getting more. There's upwards of 6 teams or whatever it is at a time from these Coffee with Jesus folks. And if you look at these, again, these are all directly related to issues that we've had throughout this case. One, in particular, that stands out is, and Nathan must receive this, one where there's a dad that says, can I have my son this weekend? The mom responds and said, let me ask his stepdad. So again, I'm not sure what the merit of this is or the point of this is, but Nathan receives that. So you've got the I miss you, Liam and Nathan. You've got the derogatory comment about mom and stepdad, which has been unfortunately an issue for Mr. Stevens since they began the relationship some time ago. Continuing to go outside the court order to try to communicate with these kids, and again, implode in their brains kind of what's happening there. These kids have done well since dad's been out of contact with them. Liam, especially the 13-year-old, is doing extremely well from where he was. We now have Nathan, who again is starting to get these communications, and dad is coming back and festering in his life in completely inappropriate ways. Not an I love you, not acknowledging. We did finally get a response, I believe yesterday, from Mr. Stevens, which again is pretty typical of him, is to push it out as long as he possibly can and drag it out. We got that late, didn't have a chance to obviously reply to that, but nonetheless, it's very much the same type of context and tone. This is the same individual who says, well, shucks, I really didn't know that. And it was by inadvertently that I sent that message to my child. It was inadvertently and happenstance that one of them happened to be about missing both of them. Happenstance that one of them was derogatory about mom and relationship with stepdad in a joking cartoon manner. Basically not taking any accountability for anything. It's just pawning off the truth. It's deflecting. It's never his fault. It's always somebody else's. And that's the problem we've had with this. I was hopeful that it would have been resolved back in, I believe it was May, when I sent the email to Mr. Roberts. It didn't. It only got worse. So again, if you look at the direct order, and if you look at just the way that social media operates, and the way, more importantly, that Mr. Stevens has historically operated in this is par for the course for him. And again, that wasn't my fault. I can't afford attorney's fees. I can't afford to do these things. I'm going through a divorce, which he is down in Clark County, and my life's upside down. My business is going sideways. Again, the same individual who fails to accept responsibility for anything, just make excuse after excuse after excuse and justify his behavior. And a lot of these, I can only consider warped thoughts of how the world is supposed to work according to him. This is clearly intentional. It's clearly volitional. This is clearly impacting Nathan. We don't believe that Liam hopefully hasn't been as in contact with his father as Nathan obviously has. But still, it needs to stop. I have no idea what else to do. He's in California. We think he's living with his mother. Attorney's fees, sanctions, admonishments, nothing seems to work with this guy. I don't know what we do on this. He doesn't want to comply with the court order, has no intentions of complying with the treatment and the evaluations, but he continues to try to sabotage his parenting efforts with his kids. And again, that is certainly admonishable. We are asking for attorney's fees, amount of $1,500. We are asking for a hefty civil penalty. I believe we asked for $250, if not $500. I'll have to check the motion specifically. I think that's certainly appropriate. We would ask for a date certain for those to be paid. And again, just some kind of measures in effect that prevent this type of abuse, because that's absolutely what it is.
Mr. Roberts?
Your Honor, before I go into the substance of it, I did email my client's declaration to Mr. Zandy's office and received confirmation the morning of last Wednesday, July 3rd. I don't know if Mr. Zandy was out of the office on Wednesday, but if he received it yesterday, it's because he was out of the office. I realized it was late when I sent it to him and his assistant. I mentioned that I had some conflicts, including a personal issue that impacted the timeline, and asked if they'd be willing to set it over so they could respond. The response was that his client wants to go forward today. That said, there's a few issues.
Mr. Roberts, just so
Yes.
you know, I have not seen it.
So that I would request that the court review that. If the court wants to take argument now and have a ruling in writing or next week, I'd be fine with that. But due to the circumstances, we did file a response, and I think it would be inappropriate for the court to not entertain that in some capacity, just in the face of the motion. So how would Your Honor like to handle that?
Mr. Zandy?
I have no issue if we were here. You've already heard my spiel and my argument. Mr. Roberts wants to give his, and Your Honor is willing to enter something today on the record, given where we're at. That's fine. If you want to take time to read the responsive materials from Mr. Stevens, and again, they're fairly brief, that's fine. I'll obviously defer to the court's direction. I don't think it's too complicated of an issue.
Okay. So I would rather read the response, and your client may want to respond to what he has to say. I don't know. If she does, then I don't know if you want to set it over 2 weeks, but I can set it over to next week.
I don't think necessarily you need to reply. There's really nothing in there that has changed anything from the initial declaration or my arguments today.
Okay.
All
right. So
I'll leave that to you.
Mr. Roberts, if we go ahead and just set it over 1 week, you want to go ahead and, well, I'd rather read it before doing anything. So let's set it over 1 week.
My client will be out of state next week, Your Honor. That's part of why we normally, I'm pretty gracious when it comes to requests for continuances. That's one of the reasons why we couldn't. She is gone next week. She's obviously one of the ones that likes to be live and present during arguments, which I understand. She won't be here next week, I guess, is the long story.
Do you want to set it to the 23rd? I don't have a problem with that.
23rd would be preferable.
Okay, Mr. Roberts, the 23rd?
Can do that.
Okay, let's go ahead and just set it over to 23rd. I'd rather have everything in front of me.
Very well. Thank you.
Thank you, Judge.
These involve the same parties, although they're different case numbers. So I think there may be some crossover. Do we have Kelsey DeMater?
Your Honor, Ms. Demeter's paralegal. I'm seeing if she can come over right now. She's in another courtroom. I apologize.
I'm present, Your Honor, Kernan Ignastu, with regards to the 8-08 case.
All right. Here, I've got.
Your Honor, I'm here. Thank you.
All right. So what I was saying is I called number 14 and 16, and I think there is a crossover of what's going on here. And So the one, number 14 is a restraining order regarding these parties, and number 16 is a contempt. The 24 matter has not been served, is my understanding, correct, Mr. Anagnostou?
Correct. My client has not been served with that action. And we have served the petitioner initially with the filing of the out-of-state judgment, and then with this motion for contempt.
Okay. All right. So what is the plan here? Is it Demeter? Is that how you say your name?
It's Demeter, Your Honor, and I
Demeter,
apologize. I just
okay.
have an unstable connection. I knew that the restraining order had not been served. However, Ms. Fillion was just on Friday in the mail received the notice of hearing on the contempt. When she was served with the contempt, there was no notice of hearing, and it was our understanding he knew that he was being tried to serve with a restraining order. So I would simply ask this court for a short setover so we can file our response, and or if I'm able to work things out with Mr. Agnostou. I know he has been out of the country, and I think I was having an email issue with his firm. But she did not have a chance to respond because we just found out that this was being set on his motion for today, because when the contempt paperwork was served, there was no notice of hearing with it.
Yeah, and that's the procedure. You file the out-of-state judgment, and there's a notice to the respondent. They have 20 days to object to that, and then following that period of time is when you can move forward on any kind of proceeding. And so that's what we've done. My client is not getting visitation. That's the problem with the setover. That's the problem with this whole case. He wants to see his daughter.
Okay. Well, I have a restraining order that's been signed off and not served yet, and I have a contempt where I don't have a response. So what I'm seeing and what I'm hearing is that both parties need additional time. I get that he wants to have contact, but right now there's an order that's been signed, that the restraining order. So with that, I'm going to set this matter over to July 23rd. And then hopefully something can get worked out. If not, then what I am doing, so both counsel understands, is working with the clerk's office to see if we can combine these cause numbers rather than having it on two cause numbers. I don't know if it's possible or not, but just so you know.
Certainly. Thank you, Your Honor.
So with that, I'll go ahead and set both matters over to July 23rd.
Thank you, Your Honor.
And just to clarify, in interim, there's no contact with my client.
Correct.
So, okay. Thank you, Your Honor.
Yeah. Okay. All right, we have Miss Bliss back, calling number 2 on the docket. Do we have Miss Petrie here still? So Miss Bliss, just so you know, she was on here and just asked about it getting sent over in front of Judge Basher. And so I believe she won't be back.
Okay.
Ultimately, that matter needs to be set over 1 week in front of Judge Basher because of a conflict of another related matter I'm hearing.
And Judge, it appears, at least from my records, that docket's closed. I don't know if we want to try and put it on there, or if we want to. I also see the week after is closed. So I don't know if we want to try and squeeze it on there, and then if there's an issue with whoever's hearing it, they can bump it over.
Okay. Let's go ahead and add it and to 1 week, because we don't have Ms. Petrie, so we'll add it to the 16th. So July 16 at 1 p.m.
Very good. Thank you, Judge.
Thank you. All right, counsel, go ahead.
Thank you, Your Honor. This matter comes before the court today on my client's motion for contempt. There's 2 motions currently before you. The first was in time, my contempt motion that was filed by my client. back on April 22nd. And then subsequent to that, we received a motion to appoint a GAL investigator, family court investigator through the court. A lot of the issues are intertwined. To consolidate those, I'm going to go ahead and just give you my comments all at once related to those. If you look at specifically what's happened, and this is a case that I think you can really only quantify as extreme. The behaviors of mom have given rise to some pretty egregious issues that have arisen with this 9-year-old child, Benjamin, who simply wants a relationship with his father. My client simply wants a relationship with his child. For reasons that are still somewhat vague, largely unknown, mom has done her absolute best to hinder those efforts, to get in the way of that relationship, and has resorted to some very unusual tactics in that. This case is well versed by the court. Judge Evans has heard prior motions and issued prior orders. This is a case that has unfortunately gotten to this point due to a lot of mom's behaviors. We are fortunate enough to have a GAL report which cites very specific examples and very specific concerns related to some of the withholdings of mom, some of the acts of mom, some of the justifications mom has used over time for withholding the child related to her concerns that my client is somehow domestic violent perpetrator. All of these continue to give rise. Ms. Corey, in her investigation and her report, did a very thorough, concise job detailing them. Unfortunately, and usually we see that and the parties level out, the actions get better, they learn to cooperate and co-parent. That has not been the case in this. In fact, this is the first case I can ever remember where one parent is giving a 9-year-old child a pocket knife or a Leatherman tool saying, you need to take this to your dad's house. And if your dad threatens you or does anything, you need to use this as a self-defense mechanism. Very unusual. Child then takes it to school and gets in trouble. Mom then says, oh, well, it's because he's afraid of dad and because of all these different issues, when literally nothing in the record supports that. If you look at the GAL investigation, and again, these are largely the same arguments that Ms. Wynn has raised initially from the beginning. GAL didn't find any substance in that. The court, through prior orders, has found no substance in that. Any of the witnesses interviewed by the GAL have found no substance in that. If anything, the GAL says this child is closely bonded with dad. This child wants a relationship with dad, wants more time with dad. And again, cites her concerns about the intentional withholding actions of mom, specifically as this relates to my client's contempt motion. And again, you got to consider this in the timing of everything. Ms. Wynn has traditionally sought outside mechanisms to support what she wants her theory and her outcome to be. And it can't be any more lesser than that than what my client has detailed for you. Paragraph 5, and this is of the order that was entered last March in 2023. Again, very clear, very unambiguous, joint decision-making for the child, including non-emergency medical decision. We got the GAL report. We filed the motion to increase my client's time pursuant to that. The court largely granted that. That time, and at that hearing, Ms. Wynn, and this was in front of Judge Evans, made the comment and the argument that, well, I'm concerned about Benjamin's diet at his dad's. I want him to essentially report back with whatever he's eating, the calories, make sure that he's at the right caloric intake amount. And I want to know basically what the menu is that dad's serving at his house. Judge Evans, frankly, admonished her for that, said that was completely unreasonable, that seemed like the control mechanism that was not appropriate. She doubles down on that, brings a very similar motion a short time later after changing counsel again tonight. We now have this again in time where we get the GAL's report in about, I believe it was January of 2023, expanding the time. Mom knows that the GAL report is getting ready to be published, knows what the outcome is going to be. So what does she do? She says, well, great, I'm going to sneak the child into counseling without telling anybody. We go into court a very short time later, a week or so later, and the information that mom provides, again, sabotages largely everything that she tries to claim now. She provides records from the counseling agency dated January 23rd of 2023. She states in her declaration, I decided to put Benjamin back into counseling. Well, that was again on the eve. That was on the eve of the GAL report being furnished, on the eve of going back into court, knowing that the court was likely going to change that joint decision making. Doesn't tell anybody, doesn't inform the GAL, doesn't inform my office, doesn't inform my client, doesn't inform the court at that time, just simply doesn't. We get into court, judge makes specifically clear, listen, we need to level out these parties. Both are parents who love their kid, both are capable of caring for this child. It's joint decision making. We don't know anything about that. We don't find anything about that until such time my client looks at the child's history of attendance at school and notices, why is he being pulled out of school so often? And again, that violates another one of the provisions that we're asking for contempt finding. Paragraph 14A, each parent has the right and responsibility to ensure the child attends school and other scheduled activities while in that parent's care. Again, she doesn't give him any notice. She just pulls Benjamin out of school, takes him to the counselor. Here's the concerning part. The counselor notes that she provides clearly indicate that everything is self-reported from Miss Wynn. She's telling the counselor, oh, since you had visitation with dad, since the court increased that, there's a substantial change in my child's behavior. Counselor says that it was all self-reported from Miss Wynn. She goes so far, and this is the part that absolutely astounds me, and I've never seen it. Goes in and tells the counselor, oh, Benjamin, a 9-year-old, has homicidal ideations about his dad. My client noticed that there was an H and an I in the counselor's notes, had no idea what it meant. Looked it up. It's homicidal ideation. So she's telling, again, this isn't coming from Benjamin. This is coming from her, telling the counselor, yeah, Benjamin has homicidal ideations about his dad. This is about a year after the fact. So this child's in counseling, doesn't tell my client. This child is apparently having homicidal ideations about my client. She doesn't tell my client. I don't receive any notification of that. The GAL receives no notification of that. Only the counselor and only directly from Miss Wynn. At no point are we provided with any of this. You would think that if someone was threatening to have thoughts of harm, whether that's self-harm or harm to a parent, that parent would be notified. At no time was my client ever notified. So she's engaging this child again in counseling because she doesn't like the GAL report, doesn't like the order of the court, and is trying to essentially withhold him and alienate him from this child who he loves dearly, and more importantly, who the child loves, my client here. Tries to get in the middle of that relationship. Then, and again, as I prior said, decides it's a good idea to furnish the child with a pocket knife and say, here, take this to dad's house because your dad is somehow dangerous. That gets to the third episode of contempt, which again is paragraph 14E4. Neither parent shall make derogatory comments about the other parent or allow anyone else to do the same in the child's presence. If you hand the child a weapon and you say, take this to the other parent's house, to a 9-year-old child, what is that implying to that child? This person is dangerous. This person could harm me. I need to protect myself. I need to be on edge around this person because somebody who I value as a parent, mom in this case, is telling me that they're bad and that I need to stab them if anything happens. Oh, by the way, mom is also going to my counselor saying that I'm having these thoughts of killing my dad when absolutely no professional has found that at any step along the way. That's worse than telling the child, in my opinion. This parent, your mom or your dad didn't do this right. They're a bad parent. I don't like them. Giving a child a weapon is taking that to a whole nother degree. Also, and furthermore, encouraging the child to change his last name at school. And again, there wasn't much that I saw in response to that in Ms. Wynn's pleadings. She's telling the child, your name is Benjamin Wynn. Drop Curtis. Don't associate with Curtis. That's your dad's. Essentially, he's a bad person, and you're going to do what I tell you to. This child is showing signs at my client's house of being disrupted. This child goes to my client's house. He has a great time. He loves my client. He fist bumps my client, says, Dad, when do I get to see you again? Yay. Also makes the comments of, my mom would kill me if she knew I was doing this. It's interesting if you look at the GAL report. Miss Wynn's prior husband, she did the same thing with him. This is a history of repeating itself with her older children from a prior relationship. And again, he states that in the report to the GAL. He says she's very controlling. She wants her way. She will only listen to her way and she will pursue it to the end. And I'm paraphrasing. That's not the exact quote. Nonetheless, it's in there. And again, this is a report that's a year old. This is unfortunately acts the GAL finding act more in a prophecy as they do as to what's happening at the given time, because everything that Ms. Corey expressed concern over is now not only happening, but it's happening to a magnified degree, which is harming this child. We will be asking for primary custody on this. We are going to file a post-parenting plan to that end, because this is alienation, frankly, like I've never seen, and it's deeply, deeply concerning. She responds, and the response, I'm going to go ahead and kind of give you a quick comment in response to the motion to appoint family court investigator. That would be Ms. Schaefer. I have no issues with Ms. Schaefer, but we've got Ms. Corey who's already investigated this. Ms. Schaefer usually does things at the front end of an investigation on an emergent basis. This clearly isn't that case. This is just further strategic design of Ms. Wynn because she wants a second bite at the apple and convince and tell her story to somebody new, knowing that the history in this case is pretty expansive. This is one of several files. If we do that, again, my client certainly has no issue with a second look at this. I think, frankly, it's warranted. I would just assume have Ms. Corey do that because she has the history of this case. She can look through that. She can know where she was a year ago. She can refresh things, talk to people again, talk to this child again, and see what's going on. Also, it flies in the face of reason. And we have this, again, the whole dietary thing. My client knew that was coming because this is literally the third time we've responded to Benjamin's diet. He's resorted, as you see from the pictures, of taking pictures of what he's feeding the child. The child is sitting there, he's eating his lunch, he's eating his dinner, he's eating very nutritious things. And I would say that some of that, and I looked at the color pictures and I thought, that looks very good. That's a good looking meal. And every single one is that way. What does she tell you? How does she know what the child is eating? Because she asks the child and engages the child in the litigation. And the child's going to do what at the age of 9? He's afraid of mom. He's already said that. I'm going to tell mom what she wants to hear. She then runs with it. The biggest concern on this, and again, this is evident. She gives him not only a pocket knife, he takes it to school, he gets in trouble. The next day, she gives him a Leatherman tool, which is essentially the same thing. Takes it to school, gets in trouble. Instead of owning that, she says, oh, it's because he's afraid of his dad. She then has her child, which serves as no other purpose than a declaration to this court. At 9 years old, handwrite out a letter that says, well, I take the pocket knife to dad's because I'm afraid of it. What information do you have to support any of that? Zero. It's one self-serving declaration from Miss Wynn that says my child is afraid of dad because of my motives and because of what I'm putting in his brain. Does that little boy who's eating his meals at dad's look afraid of him? Does that little boy who met with the GAL seem afraid of him? No. In fact, the very opposite is true. And GAL stated this, I think, very succinctly in the report, that this child loves dad. This child wants more time with dad. And a child who wants more time with one parent is clearly not afraid of that parent. And making this child write a letter to the court, which essentially is what it is, outlining and detailing that, again, is admonishable and it's reprehensible. But this is the stuff she continues to do. We need some action on this. We're asking for a contempt finding on the 3 violations cited in my client's motion. I think it's clear. I think it's definitely intentional. It's willful, and it's in violation of the order. She's doing it on purpose. We still have been provided no information from the council that I'm aware of, and I'll let council address that. I haven't seen anything. We have provided with no schedules for when this child is seeing the counselor outside of what we can glean from the school records of when she's pulling him out of school. She has excused absences for the child. We don't know what those are. She has advanced notice absences for the child. We don't know what those are. There's upwards of, I believe, 14 or 16 that were cited in my client's declaration. That's problematic. And we have somebody who is directly implicating this child in this matter when this 9-year-old child wants nothing more than a relationship with mom and a relationship with dad, wants love and support from both of them. She's doing everything in her powers to sabotage that. She's putting devices on the child's electronics so that she can show up randomly at the park where she knows the child is going to be with dad and appear randomly. Again, this is a mom who is controlling, overbearing, and needs to stop the sanctity of her own child and his peace. She's unwilling to do that. That's our request. We certainly think this is contemptible. We are asking for the attorney's fees and civil sanctions as cited in our motion. And we're really hoping this is a wake-up call to Ms. Flynn that this isn't good for her kid and she needs to stop doing this.
Council?
Yes, Your Honor. So my name is Tanya Green. I'm here representing Ms. Wynn, who's here in person because orders of cause required her personal attendance today. This was continued previously due to vacation, and that is why our subsequent motion was filed. We have to be heard with this at a later date. Regarding the contempt allegations, it's interesting that Mr. Zandy's arguments basically expand far beyond what his own client wrote in his declaration. There's nothing in his declaration stating how or that his client knew my client gave the child a weapon, told him to use it to protect himself from his father. In fact, her declaration states the opposite. She did not give him the weapon to take to school, to take to his father's house to protect himself. He did it without her knowledge. But father yet continues to complain that mother has incited the child to take this weapon to school to protect herself or protect himself from his father. The fact that Mr. Zandy goes on and on saying the child has never been afraid of father is completely incorrect, considering the jail report from February 2023 says the child told the jail he yells at my mom and almost shut my arm in the trunk one time. He said that he worries that his dad is going to be worse than before. He's already bad enough about a lot of stuff. He wasn't specific, but there were concerns because the incident he mentioned is he almost had his arm slammed into the trunk of his father's car, trying to get his bike lock out of his father's car when he was angry. So saying that the child has not been fearful ever of father is not correct, and it is in the jail report. Secondly, like I said, that statement that my client was responsible for the child bringing a knife to father's home is completely inaccurate. He has no basis for that. He was not there personally. He did not. If he relied on the child's statement, we have no information of that. He has nothing in his statement. There's no basis for his allegation at all, other than his assertions that my client did this. Therefore, I don't think she should be found in contempt because there's nothing to prove that that actually occurred. In fact, my client states the weapon was taken to school without her knowledge. In fact, a weapon was taken another time and father had it and returned the child to school with a weapon in his fanny pack as well. So to say that my client is responsible for that when he had access to a weapon in his father's home as well is not accurate. That say my client had put the child in danger. Father didn't take any actions to check the child, knowing that that incident already occurred, and had no indication that he was concerned about his safety. In fact, he was contacted by the school, and I don't believe he made any follow-up contact with them. We provided the letter, which is provided in the records, showing the concerns when it happened at our concerns, and had specifically asked for a follow-up investigation because there's not been an investigation since the child began supervised visits with father. That was his first contact after several years. And those supervised visits, my client said were concerning because the child was afraid of being kidnapped during that time. And that's in her declaration. Regarding the joint decision-making, we laid it out pretty clearly. The court ordered counseling. My client put the child in counseling. My client had sole decision-making in the first parenting plan. In the second parenting plan, my client still had sole decision-making and had enrolled him in the counseling. As the counselor report says, he was dismissed because there were no concerns. The second time he was enrolled was right before he started his unsupervised time with father, and he was becoming agitated. It's really concerning that the child's father relates the child as having a homicidal rage. He has no records or information. He doesn't even know what the HI was in that report. In fact, the client stated that he had wished his father dead. Never made any reports that he was going to kill him, never made any threats, but father takes it out of, I don't know, out of the universe, saying like all these awful things about his own child that he's concerned about with no basis, no information, no facts. Far be it beyond for me to make decisions about, what to say about your child. That is concerning that he would make these allegations against his own child. And then, to say that he's been providing for the child and that my client is the one that's a problem. My client has reported abusive messages, which we've shown where he's told her to provide tax return, tax affidavits for the next 8 years for the child's life, even though court order says he has to be current in child support and he isn't. That kind of abusive conduct is the issue that we were dealing with at the outset of this case, and which are reported and why he had therapy with Olivia Lovely for domestic violence. Yes, he completed it, but it seems there's still ongoing controlling issues and behavior because now he's saying that he wants to know every time the child's removed from school. There's nothing in the parenting plan that shows that he is required to get notification if the child goes to a birthday party, if the child goes out of town with mom for an event, that she needs to notify him of all these incidents on why he is out of school. The court order says that he is to attend school, but father does that to the detriment of the child by taking the child to school when he's injured and then not telling mom about it, mom finding out after she picked up the child from school about the injury. So I think that my client is on the better side of protecting the child and doing what's right. She's proactive in his education, making sure all his assignments are taken care of, and none of the absences have affected his grades, as you can tell. Other than father trying to be controlling and telling mom what she can do with her time, with their son, is very concerning. And it goes on with the controlling behavior that father has had throughout these proceedings. Regarding the Columbia Wellness, it was disclosed, it was in the discovery. In fact, reports and records have been provided throughout this case from Columbia Wellness. Father's been aware of that provider. There was no change in that provider or in the care provided. So I'm not certain at what point joint decision-making came up because it wasn't a new issue. It was an ongoing treatment that he was already doing. She felt it was standard care because that's what the court ordered, go to counseling. She put him in counseling, and that's where it was left at. He had notice, he had ample records, he had opportunity to get them. And in fact, his contempt says specifically, mom restricted him from access to those records by just some blatant statement. We don't know who he talked to. We don't know when he talked to him. We don't know if we emailed him or called. We have no information of the father's blanket statement saying, I tried to get access to the records and I couldn't get them. When we brought it to court's attention in the letter that there's no restrictions on the child's records, and father and his attorney has every opportunity to get records if they request them, there was no response, which is surprising. But, far be it for me to say, what's contemptible, but that is concerning when you make a blanket statement and it's proven false. That was the main issue about access to records and the reason he made his request. In fact, in his other orders, he asked to be allowed to communicate with any and all healthcare providers, including counselors.
Judge, I'm going to object. I don't know where we're going with this, but I think it's well outside the scope of the declarations as far as I can recall. I'm not sure how it's relevant to the issues either.
I was addressing his other orders in his motion for contempt. He's asking the court specifically to allow to communicate with any and all healthcare providers. That is in his motion. I don't know if he doesn't want me to address it.
Just go ahead and summarize. And I read everything, but Go ahead.
So the concern is that, father, all the claims that father are making has provided no proof. They're blanket statements that he's made. He said that mom had given the child a weapon to protect him from father. Not true. He said that he had no access to the healthcare records. Not true. He said that, that he had no notice about the child missing school. There's nothing in the court order that requires my client to give notice every time she takes him to an event or activity. So that's not a contemptible matter. Regarding Regarding the never asking the caloric intake of the child, my client has never asked for him to provide any kind of dietary calendar or request. In fact, she's provided multiple times the request of the dietitian. The child was keeping a food calendar or food journal, and that was requested by the dietitian to make sure the child's getting adequate, healthy options. And that's all my clients asked for throughout this case. The statements that my client had filed the same motion again after obtaining control is not accurate. The motion was related to summer visitation, so the child could attend his sister's wedding, was related to his pickup times being inconsistent and was modified, and related to other issues such as him providing the passport documentation. It had nothing to do with all the issues that were raised before. Yes, the issue about the healthy choices for the child was brought up, but so was the concern about his neglect, his not bathing, his not changing clothes over a weekend visit with father, and all the other issues that seem to be ongoing, which is why we're requesting family court services. At this point, we think it's most appropriate to make sure that father doesn't just continue to make false allegations against my client based on nothing. That's what we have. We have absolutely nothing. There's nothing showing that my client has experienced father. He has no statements from the child that he's witnessed or anything to show that she's been disparaged child or father to child or any other of the complaints that he's made in his accusations. Given the accusations he's making against my client and my client's concerns about the child's health and neglect in father's care, as well as obvious fear if he's bringing a knife to school, we are asking that some investigation be done. We had asked for family court services, so it would be quicker as far as a response to get back generally, and it would be a lower cost than re-engaging a guardian ad litem. My client also has concerns about bias and the timeliness of getting the report last time, as well as other issues she brought up. It's the other reason we're not asking to re-obtain trial Corey, but asking for a secondary investigation that would be brief to the issues that are being presented now. So if the court finds that my client is not in contempt, we are asking for fees for my client having to appear today, responding with material showing that his statements are completely false, and asking for the court to enter sanctions to prevent this from occurring again.
Mr. Sandy?
Let's look directly from the letter that was provided by Ms. Wynn on behalf of the child. And let's see if a typical 9-year-old is going to put this voluntarily on paper. Stated 2/1/2024, and it's edited. The vice principal, Mr. Lumberg, talked with me because I had granduncle's pocket knife in my fanny pack. I took it because I needed protection from my dad. I kept it with me because I had to miss his funeral. Yesterday, dinner at dad's. So we switched gears. It says mac and cheese, Kraft, water, no snack, and then it's signed Benjamin. So what 9-year-old is going to put in a letter to somebody, obviously his mom, here's what's happening without any kind of coaching. Oh, by the way, what'd you have for dinner last night? Well, I had Kraft macaroni and cheese. I had water. I had no snack. What 9-year-old is going to put that on paper? What 9-year-old is going to remember what they had for dinner a night or two prior? Nobody. So come in here and say, well, this is all on Benjamin's own. Who gave him the knife? It's from his granduncles. Again, that's undisputed. Mom knew he had it. Mom gave him the granduncle's knife. Mom gave him the Leatherman tool. That's not my client sitting there assuming anything. It's in the information that they provided. This HI, homicidal ideation, again, that's in the information they provided from the July 2023 letter from the counselor services for the intake form. I mean, it's all in there. So now try to back off that and say, well, I don't know where any of this comes from. It's in the material they gave. And if there's homicidal ideations or that's much angst against the parent, and a child is voluntarily going to his room at 9 years old and writing something like this, you would think that would be given to the other side. I'm not going to ask for a letter from a 9-year-old because frankly, I think it's deplorable when kids write declarations in these cases. I'm not going to go out there and ask every attorney, hey, did the 9-year-old write a letter? Should I see that? Hey, does the 9-year-old have homicidal ideations about my client? Can you give me that information? That's preposterous. That's not how it works. And we know that. And this is so transparently obvious as to what's happening, what mom's trying to do, that again, it is ultimately concerning to where this child's head is. Mom clearly has some issues. I don't know if those are mental health. I don't know if those are emotional. We'll have to decipher that going forward. She's starting to put this on the shoulders of a 9-year-old who again, just wants a healthy relationship with dad and a healthy relationship with mom. There was no response as to change your last name. What does that tell a kid? There was no response to, he's got a knife, I gave him a knife, and then knew he got in trouble, gave him a Leatherman, knew he was taking that to dad's because this letter was written back on February 1st, so she knew he had it. There's no response to any of it. There's no information given to any of that. And she sits on whatever she's sitting on with the counsel. Doesn't inform my client, doesn't make him involved, doesn't give him any access to providers, and instead says, well, I'm going to keep building my case. I'm going to keep trying to do all these things to the detriment of the kid, to the point of having him write a declaration against his own dad, who he loves tremendously. That's deplorable. That's what we have. It's clearly intentional. It's clearly a contempt. Oh, and as far as the appointment of family court services, that reverts and goes back to a GAL anyway. So I'm not sure really. I think that's in the rules. Your Honor would certainly know better than I do. But I think this ends up with the GAL. And we have no issue with Ms. Ford being reappointed. We would just ask that be on a 50-50 basis.
So I have reviewed the files of record and heard argument here today in regard to the contempt matter. The court does find the mother in contempt and an intentional and willful violation of the orders of this court based on the following. The mother has failed to comply with the requirement of joint decision-making in the non-emergency medical decisions. That includes mental health counseling and our treatment, meaning Columbia Wellness treatment. And when talking about that, yes, the court may order it, but you still have to consult. You still have to have a conversation with the other parent where that child's going and what's going on in regard to that. As far as the attendance at school, the mother failed to comply with seeing that child is attending school as required. The mother has taken the child out of school for a significant number of times, not just 1 or 2 or 3 or 4, but a significant time for unknown reasons. Also, the changing of name is just inappropriate. Child has a name. The child will use that name that is on the birth certificate and not drop one name. This child has a right to love both parents, have a relationship with both parents, and the interference that the court is seeing is totally unacceptable. In regard to the pocket knife and the child arming himself, especially if there's this idea that there is some ideation, homicidal ideation, and then you give your child a knife. This is a product of derogatory remarks and statements by the mother against the father, and that the mother is monitoring the activities of the father and where he takes the child. Talk about who's controlling here. There's only one person that the court sees as controlling, and that is the mother. Based on those violations, the court will order that the mother pay a civil penalty of $250 within 14 days of the date of the order. The mother can purge the contempt by complying with the orders of this court, including not treating the father and child, and pay $1,500 in attorney's fees to the attorney, Chad Sandy, within 60 days. The court also wants to have the mother have a mental health evaluation with input by the father and the guardian lineman. I'll get to that in a minute. By at least a master's level degree. The court needs the mother to understand if the mother continues this controlling behavior in regard to food, in regard to where they go, unless it's something that violates the court order, the court will consider jail time. This has gone beyond acceptable, and the court will not let this continue. The mother doesn't want to follow the court orders, then there will be consequences for that. As to the mother's motions, the court will reappoint Ms. Corey to investigate the claims of the mother regarding child and whatever else that needs to be done to be paid 50-50 private pay. Ultimately, the court echoes the words of Judge Evans, that what is viewed by the mother being a good parent is that of someone that wants to control all the actions of another. To have a 9-year-old child make statements and then claim the child is, in this court's view, abusive, controlling behavior, and it needs to stop. An additional amount of $500 in attorney's fees shall be ordered for the necessity of having to respond to the mother's motion by the father, also due within 60 days.
Sorry, is that related to my family court services motion?
Correct.
And Your Honor, can I ask the basis for the mental health evaluation? There's nothing in the motion or related to the GR report, nothing in the history that had requested that.
What the court sees is potentially a mental health issue, and the court wants an evaluation.
Since it's father's request, is he paying for it? It wasn't formally a motion.
At this point, no, the mother will be paying for it.
Presentation in 2 weeks.
July 23rd.
Very well, thank you.
Just a moment. Check my calendar, please. And 9 a.m. docket, that's fine.
Okay.
I see Mr. Jones, but I see he's muted. There he is.
I'm here. There we go.
Matter. Counsel, go ahead.
Thank you, Your Honor. And for the record, Carly Bliss on behalf of Elizabeth Murrow, the moving party and petitioner in this matter. We're before the court today on several motions, and I trust that Your Honor had the opportunity to review the voluminous amount of documentation provided to you for purposes of today's hearing. So with that, I'll keep my arguments brief. Looking first to our motion to waive mediation, I didn't receive a response from Mr. Montez on this matter, but I think it's very clear. There's documented domestic violence in this case. The current parenting plan has limitations for domestic violence, requiring a victim to participate in mediation with her abuser. I think is contrary to the initiation of the rule, contrary to case law and statutes. So we are asking the court to waive the mediation requirement. The court did enter an order back in February of 2023 requiring these parties to at least attempt mediation. So we're asking the court to waive that requirement today. Moving towards the motion for contempt, frankly, this is a simple matter. Mr. acknowledges he's in violation of the court orders as defined in our motion. He has failed to pay my client's vehicle since March of 2023. My client provides to you that this vehicle is now in threat of repossession, so she can't even drive the vehicle. This is a willful and intentional violation of that order specifically that Mr. acknowledges. I haven't been paying it. He claims poverty or the lack of funds, yet fails to provide any documentation to substantiate that. He failed to provide any sort of income statements. The bank records that the court has already ordered that he provide, which is the Bank of America account, he's failed to provide those documents. He's failed to provide any sort of proof or justification as to his lack of means, which he claims for this court as a basis as to why he's not paying. Nevertheless, he is intentionally failing to abide by that court order. Moving to our secondary basis of contempt, the right of first refusal, as contained in the current parenting plan. If either party is unable to care for the children, they're supposed to offer the other party the opportunity. Mr. acknowledges the fact that he rarely spends his time with his children, acknowledges for the court that his father picks them up from school, his father or his mother watches them until he comes home, if he comes home before they go to sleep, spending substantial time with grandparents as opposed to either parent. My client provides for you that she's never been afforded the opportunity to care for the children and is always available to care for the children. The specific purpose of this inclusion in the parenting plan was to allow my client to continue to provide primarily for the children. I'll get more into the parenting plan and our request to modify that here in a moment, but at least under the current parenting plan, there is a right of first refusal. Mr. is refusing to allow my client the opportunity to care for the children while they're in his care while he's working. You read likely my client's declaration indicating that the children have reported that they go to father's work during his time and are forced to sit in a restaurant for hours on end. Either that or they're with his parents, none of which they are with him, which is what that order requires. Looking to another basis of contempt, my client provides for you that under the current bench orders, Mr. is to continue to insure both her and the children on medical and vision and dental insurance. He failed to do so. That's another basis for contempt. Further, there are orders currently in place that require Mr. to maintain the home, maintain the utilities, maintain the mortgage, maintain various debts, all of which include my client's name, and all of which she has failed to do so. She provides substantial documentation as to late mortgage payments, late utility payments, failure to pay, in particular, the synchrony bill, which the court has already ordered him to pay. My client provides for you that but for her paying that $166.86, it was going to be sent to collections. And that was Mr.'s obligation as to the bench order that the court had already ordered that he pay. So for purposes of contempt, my apologies. Lastly, there is a $5,000 moving expense that the court also ordered Mr. to pay my client when she did vacate the home back in 2022. Again, she was the primary provider for the children caregiving. Mr. was a primary breadwinner. My client left the home, all of the furnishings, and took the children and fled after the domestic violence incident, which led to their separation. The court had already ordered that he pay $5,000 towards her moving expenses to assist her in getting back on her feet. He's failed to do so. And it's clear based on his response and based on his actions to date that he's doing so in continuation of his control and intimidation of my client. This is the last basis of control that he has over her now that she has fled, and he's continuing to keep grasp on her by failing to not only comply with court's orders, but assist her and the children with moving on. So for purposes of contempt, we do believe that it's even acknowledged by Mr. Montez in his responsive pleadings. It's a willful and intentional violation of the court's rulings and orders. We are asking for the $5,000 moving expenses to be reduced to a judgment. It's clear that Mr. has zero intentions of paying, so we do need that at least reduced to a judgment to be able to collect on that moving forward. We are asking that $166.86 for the synchrony bill that my client paid, that was ordered to be paid by Mr. Montez, be reduced to a judgment as well. We are asking for attorney's fees and costs for having to bring this motion. We do believe that it's appropriate, especially given the willful and intentional violation of the court's rulings. Next, as to the motion for temporary family law order, my client is making various requests, most importantly as it relates to the parenting plan. Again, as my client indicated and as I briefly just argued, the children are currently on a joint residential schedule. Frankly, the fact that a parenting plan was entered with 191 findings for domestic violence and assault, and the court still approved a joint residential schedule is concerning. My client provides for you that at the time that this parenting plan was entered, she was freshly out of this domestic violence relationship. She did not have counsel. She did not have an attorney. She didn't have the means for an attorney. She agreed to this residential schedule in hopes that removing herself from Mr.'s grasp, that he could continue to care and provide for the children. However, as my client provides in her declaration, it has been anything but. She's provided substantial documentation and text messages of Mr. continuing to attempt to control her and control her ability to raise her children while they're with her, refusing to allow them to be with her during his time, despite that first right of refusal language. There's significant control here. Further, the parties are required, at least under two of the major decisions, to have joint decision making. Again, statutes and case law are very clear that if there's findings of domestic violence, that's inappropriate. We are asking the court to modify the parenting plan to allow not only my client to resume the role as primary caretaker, which she has done the entirety of these children's lives, but to put these parties back to where they have been and what is in these children's best interest. Mr. acknowledges in his declaration that he has Mondays and Tuesdays off from work. That is my client's request, is that on Mondays and Tuesdays he have the children. Again, even in his declaration, he acknowledges that every other day of the week he's working. So the children are with his mother, whom my client provides some significant concerns regarding her not only abusing Mr. as a child, but also reducing to corporal punishment of the children. My client has objected from the very beginning that she be alone with the children. Again, she does not drive, so in the case of an emergency, she's incapable of providing for the children, in addition to the history of corporal punishment on these children. In addition to his mother, his father also, like I mentioned, provides caregiving. These children need to be with a parent. And that was the initial discussion between these parties when creating this parenting plan, is to ensure that these children are with a parent at all times. Mr. frankly doesn't have the ability to care for these kids. Again, he works every day but Monday and Tuesday, and even sometimes works on Monday and Tuesday. My client is asking the court to approve of her parenting plan, which allows him the quality time with these kids, allows the kids to be kids, and allows them to not have to be parentified to caring for their siblings. My client does provide in her declaration the concerns of Gabriella putting the kids to bed and getting them up and getting them ready because Mr's frankly not there. This is the parenting plan that's in the kids' best interest. She did make a request to appoint a guardian ad litem. If the court sees fit, I would make that pitch here today. Depending on what Your Honor decides to do with the parenting plan, one may be appropriate in this matter. Looking next to support. My client provides for you that throughout the entirety of their marriage, Mr. was the breadwinner. She was a primary caretaker for the children, and it wasn't until nearing the end of their marriage that she got a job. She's currently employed at the emergency support shelter, making modest income, $23.69 an hour, working 40 hours a week. Mr. alternatively has always been employed in the restaurant business. She provides for you that he was a part owner in the margarita factory, that nearing the end of their separation, that relationship ended with the margarita factory, and Mr. now has Rigo's restaurant here in town. She provides for you the deception of Mr., that it was always the intention of him and his siblings to open this restaurant. And of course, naturally, once the dissolution began, he took his name off of the restaurant. This is clearly for purposes of reducing his income and reducing his obligation to support his wife and children. We have imputed him for purposes of support at his historic wages, and we've provided those to the court under seal for tax returns. Mr. has historically earned upwards of $200,000, and that is reportable income. Obviously, as the court is aware, when folks are self-employed, there's ways to reduce that reported income. Nevertheless, until we get any sort of documentation from Mr., none of which has been provided. Again, we've received no pay stubs, no wage statements, and no bank statements, aside from the few that he did provide to the court, which it is clear that those are not his normal and his primary checking account. We are asking the court to impute him at that $200,000 a year for purposes of child support. Again, since the parties separated, Mr. has not paid any support to my client. He has paid no spousal support, no child support. He hasn't even paid the obligations that he was required to by the court previously in lieu of making those payments. This is very concerning and is, again, continuing to control my client financially, at least at this point, by preventing her from having the same means and ability to care for herself and the children as she did during the relationship. We are asking the court to enter an award of spousal maintenance, at least pending further disclosure from Mr. as to his financial status. We believe that $1,500 per month is appropriate in this matter. We are asking child support based on the child support worksheets I've provided to be entered today. As it relates to the home, my client has raised significant concerns not only about Mr.'s ability to maintain the home, which he's required to do by this court, but it's the largest asset of the community. Mr. claims that he cannot afford to maintain the home and support his wife and support his children and abide by all of the other obligations that the court has put on him. We are asking at this time that the court order the home be sold. My client does not make this request lightly, but again, this is the largest asset of this community, and my client is simply wishing to preserve that. Mr. has, again, been late on various mortgage payments, utilities, and the like. The upkeep of the home and the farm is significantly deteriorated, as my client has provided in her declaration and photographs. Frankly, at this point, it's the prime opportunity to sell. We're in the middle of summer. My client is asking that the home be sold, Mr. vacate the home immediately, and that any proceeds that are received from the home be put into either mine or Mr. Jones's trust account. Alternatively, if the home is not ordered to be sold today, my client is asking for the court to enter an order requiring Mr. to switch all of the utilities to his own name. Again, my client has provided to you that she is constantly receiving late notices. Her credit, frankly, is being impacted drastically, especially from the mortgage being paid late. Obviously, that's a secondary issue, but primarily the fact that all of the utilities remain in my client's name, which then impact her ability moving forward to gain utilities in her own name. We are asking the court to make this order. We do believe it's appropriate, especially given Mr. is in the home currently, and if the court orders that he remain in the home. Next, as it relates to a restraining order, as Your Honor likely saw, the court back in December of 2022 entered into a bench order that the restraining order in this matter would continue moving forward. I believe it was due to a clerical error that was never entered. My client is asking the court to enter a restraining order today to continue her protection. My client provides for you that there has been several instances of Mr. attempting to get her alone, attempting to have inappropriate conversations with her, touching her when they're at community events, things of that nature. Again, this is a significant history of domestic violence where my client was strangled in front of the children. This is appropriate moving forward. The court had already entered that order previously. It was never reduced to writing. So we are asking the court to enter that order today as well. I do believe it's appropriate as the court has already entered it. Attorney's fees, again, my client does not have the means to have counsel today, did not have means for the last year and a half that this matter has been pending. She would be at a significant disadvantage, especially now that Mr. Montez, has counsel resolving this matter appropriately. She is asking for a contribution of attorney's fees in the amount of $3,000. I do believe that that's appropriate given the fact, given the financial status of the parties and the stature where we are currently. Lastly, and a more minimal request, but one of significant value, my client indicates that both her and the children's birth certificates, passports, social security cards remain in the home. She is asking the court to order that they be returned to her. There's significant concerns, of Mr. Leaving with the children. The children do have dual citizenship with Mexico. My client has concerns if Mr. is to maintain possession of those documents. Dependent on the outcome of today or future proceedings, my client does have concerns that he would flee with the children if he does maintain possession of those documents. And that's the basis of our request today.
Counsel?
Yeah, Your Honor, I'll start at the end here. I don't have a problem with the passports being returned, but I think it's disingenuous of Ms. Bliss to argue that my client's going to flee. She simultaneously believes that my client owns a part of the business, but is willing to drop that to run away to Mexico. So we're okay returning the passports. As far as the contempt, my client is simply unable to pay. His last job ended when this case kind of started based on these allegations from mom about strangulation, etc. He has been unable to find a job commensurate with what he had before. And mother is really not helping him do that. She's online bashing him, bashing his new employer, telling anyone who will listen that he's an abuser and that he's strangling her. I don't understand how she thinks he can earn the money he used to earn when she's online telling everyone who will listen that he's an abuser and they should not support him. The mother needs to either stop that so my client can build up clients at his restaurant, people actually want to tip him. She needs to knock that off. The bank account statements show my client repeatedly taking cash advances to pay things, debt payments, and it doesn't show any real income. His income has decreased dramatically now that he's working for his family restaurant. As far as the parenting time, I don't understand. I'll touch that on later. The health insurance, he lost his job. There needs to be some switch with how those children are going to be covered, whether it's through the Washington State plan or if mother has a plan. I understand she's now working 2 jobs. The mortgage has been paid and is current. We provided current printout of the mortgage statements or mortgage payments. They are current. Perhaps they have been late, but they are current. He has not violated the mortgage or the utilities. Mother doesn't even allege that they are currently unpaid. She just alleges they have been late. That's not a violation of any court order. As far as the contempt, he's unable to pay attorney fees. He has no more money to pay in attorney fees. You can tell by his bank statement. He is taking cash advances to keep money in that account. There's no money for him to continue to move forward. As far as the temporary orders, my client provided a list at the end of his declaration showing all the additional time he has had over the time this case has been pending. He has had much more than 50% of the time. Mother has repeatedly given him more days, more nights, more mornings for parenting time with the kids. There's no indication in mom's pleadings that it's detrimental to the kids at all to be spending time with grandparents, which frankly the court should appreciate. It's a good factor that the kids are connected to more family members than just the parents. Sitting at a restaurant is not detrimental to the children. That happens with small businesses around this country every day and is not something to fault Mr. with. We don't know mom's work schedule. She stated in her declaration that she works 2 jobs. We don't know what her work schedule is in that regard, so I'm not sure how we craft a parenting plan based on the parties' work schedules. Mother has said she's also available all the time. I'm not quite sure which is which. Is she working? Is she working 2 jobs or is she available all the time? What's the case? That question needs to be answered before this court if they're going to modify the parenting time schedule at all. As far as spousal support, it's not equitable to use father's prior income to determine current spousal support. There have been significant things that have happened in that time. My client has lost his job at his old employer and is now starting something new as an employee with his family business. And then again, mom's online harassing him, telling everyone who will listen, who will comment about how they like the restaurant, that my client is an abuser. This is not appropriate. It's not helping him get the income he used to be at. It's not correct that my client is the owner of the new restaurant with his family. Yes, of course, the plan was to be a member of that or an owner of that business. But once the divorce started, he didn't have the buy-in. Nobody's going to let you be an owner of a restaurant if you don't buy in. You don't just say, "Hey, you're an owner. Don't have to pay us any money, but you're an owner." So that's what's exactly happened there. Is his family moved on without him to build up and to own this business. They've graciously allowed him to work there. That's the extent of the ownership of that business. As far as not paying child support or spousal support, he has had the kids for more than 50% of the time over the last year. He doesn't earn the same income he did before. There's no need for a change. There's no need for him to pay spousal support or child support during that time period. He has maintained the marital residence. Wife was living, I believe, free at her mother's home. There's no need for a transfer of spousal support during that time. As far as the sale of the home, the pictures show my client has maintained the home. He's maintained the farm. He has maintained the mortgage. It would be inappropriate to sell the house at this time. Selling the home is a decision for the trial court. It's a decision for the trial court while they decide the asset division. It's not time at temporary matters inappropriate to order the sale of the house, barring, if we were entering foreclosure, yeah, sell the house, but we're not there. The house is maintained, the mortgage is paid. My client's parents live at the home. This home needs to stay status quo until we can get a final overall resolution of this case. My client has no problem switching the utilities to his name, getting out of wife's name. That's totally fine. And I do understand the issue with the restraining order. Yes, that was ordered by the court previously. Sounds like 2 pro se parties didn't get the order entered, so we don't have an objection to that. I would like to include with the restraining order kind of a mutual non-disparagement clause that mom gets off Facebook and stops telling anyone who'll listen how my client is an abuser. Frankly, it'll benefit her in the long run if she does that. It'll help my client's income increase. Assuming mother doesn't want to cut off her leg to save her foot. Lastly, my client doesn't have any funds available to pay attorney fees. You've seen his bank statements. He never has sufficient funds in there. He's always taking cash advances to cover his bills. So there's no attorney fees available for mother or even for my client in that matter. Thank you.
Rebuttal.
Just briefly, Your Honor, Mr.'s claim of his inability to pay expenses, doesn't have any money, it's inappropriate to impute him at his previous wages. What option do we have at this point? Mr. has refused to provide any current wage statements, anything to substantiate what he's making now. The bank statements he does provide to the court show very minimal transactions, and it's very clear that that is just a bank account used for purposes of bills and nothing else. What hasn't been provided is what the court has already ordered he provided, which is his primary bank account, which is the Bank of America account. That bank account is going to show how much money he actually has, what his actual income is, and he's concealing it to the court for purposes to isolate himself and to prevent the court from finding that he does have the ability to pay, which he does. Historically, he has earned sufficient income to not only support himself and my client and the children, but to go on and be above that and have a luxurious lifestyle, which my client provides for the court, that they had anything and everything they ever wanted during the course of their marriage with one income. Now to claim that he's impoverished, has no ability to keep his head above water, yet fails to provide any sort of documentation as to what he's earning is disingenuous. We are asking the court to impute him at his prior wages. If he had any sort of disagreement with that, he would have provided it. He hasn't. And it's clear that there's a reason for that. The court has already ordered he provide those bank statements. He has refused to do so. Even in my client's motion, she again makes the request that he provide those statements. He has refused to do so. One can only assume why he's doing that, and that is for purposes of reducing his income, for purposes of spousal support and child support. There is a change of circumstances here. My client works one job, not two. She provides for you that once the parties separated, given the fact that she had no support from Mr., she had to do whatever she could to get on her feet. At one point, she did have two jobs. Now she works one. That is provided to the court. She works at emergency support shelter, making a modest wage. There is absolutely a need for my client, and there is an ability to pay from Mr., whether he's choosing to provide that or not. As it relates to the time with the children, my client provides for you that she abided by the right of first refusal, unlike Mr., which is why he did have additional time in the morning or the evening when she was working. Mr., again, has not done so in violation of the court order. My client is asking for the parenting plan, which is going to provide the children with the parents during their residential time. Mr. acknowledges that he takes the children to work with him. Whether that's detrimental to the kids or not, there's an order already in place saying that if he has to work and be away from the children, whether he brings them with him or not, he is not spending quality time or adequately parenting them. They need to be with the other parent. He's refusing to do so, again, to control my client. To require my client to abide by this rule so that she's not found in contempt, but to simultaneously not is disingenuous and inappropriate. We are asking for contempt on that in every other basis we have. Again, to claim that he is anything less than a co-owner of this building is again disingenuous. The restaurant is named after him, Rigoberto Muro Montes and Rigo's Restaurant. It is very clear that there is some shady business, for lack of better words, happening here for purposes of isolating him in the business from this divorce. And it's very clear. My client provides to you the incorporation documents when this restaurant was created. He was a governor on it. Now he is not once this matter was begun. It's very clear that he is attempting to reduce his income and simultaneously not provide any income for the court. So we are asking for the request within our motions. My client acknowledges her inappropriate behavior as to the social media, as was an isolated incident, obviously as provided by Mr. in this incident. She was frankly frustrated that folks were personally attacking her on this restaurant page and responded reactively. She agrees to not do that moving forward. She does know that it's inappropriate, at least for purposes of the business and in purposes of social media. The children are going to see this one day. That said, what she said was true. Mr. did assault her, and that's clear in the evidence. That's clear in the criminal charges that were brought against him, and it's clear in the DV finding in the parenting plan.
So I did review the files and record, and there are a number of issues that the court is looking at. First, I'm going to go through the contempt part of this. Based on the files and record argument here, the court rules as follows. The court does find the respondent in contempt and an intentional and willful violation of the orders of this court. First, in regard to the right of first refusal, the mother has a right to have the children when the father is working. It is unacceptable to have them sitting in a restaurant or alternatively going to a grandparent that was in the parenting plan and is required and it is not being followed. In regard to the car payment and insurance on the petitioner's Denali and upkeep of the family, maintain and upkeep the family farm, maintain the eye and dental insurance for the petitioner and children, and pay, I think it's Synchrony, $319 and pay $5,000 for moving expenses. Clearly, the respondent has failed to make those payments. And as much as he argues that he does not have the funds, the court does not accept that. Bottom line, that it's always interesting that people have this certain amount of money, then a dissolution comes along and suddenly they have no money. The court finds that he is voluntarily underemployed and don't know exactly what's going on, but that he has the ability to make these payments. Based on that, a judgment shall be entered for $1,000 in attorney's fees, $166.80 for the Synchrony bill, and $5,000 in moving costs, and the amount shall be paid within 30 days. The respondent can purge the contempt by coming into compliance with the parenting plan and pay the amounts within 30 days. That does not occur, then the matter can come back before the court to modify the parenting plan to better reflect the working hours of the respondent and the house and property be placed for sale. I'm not doing that today. The court expects compliance with orders of this court. They are not just a piece of paper. They are orders of the court to follow, and the court expects it to be done. Further, the request to waive mediation requirement is granted so that it will not be a requirement. And going through the additional requests, I basically have said it, but as to the request for a temporary parenting plan, the court is going to do the following. Court is going to order the appointment of a guardian ad litem to be private pay at 50/50. Who are the next three?
We have Karen Lawrence, Beth Fellows, and Amy Turnbull, Your Honor.
I would strike Miss Lawrence.
I missed that. I couldn't hear the other two.
Beth Fellows, and who was the third one?
Amy Turnbull.
And Amy Turnbull.
I will not strike Turnbull.
Okay, that leaves Beth Fellows. Right. All right. Again, the court is not going to be changing the parenting plan at this point. From what it is to first see if the father starts complying, the court would like to see that happen with the first right of refusal, and second, to get the guardian ad litem on board to look into things before another change. However, if the father does not comply, then the matter can be noted up again, and the court will look at the modification of parenting plan early. Court's not going to change the family home yet to see if the respondent comes into compliance with payments. Sounds like that's done, but he needs to maintain that. If not, then the matter can be noted up again, and the court will consider having the house put up for sale. Child support, the court does impute the income of the father and adopts the income of the mother as set forth by the mother. And it can be figured out from there. I don't know if anybody's paying for any health insurance at this time, but they should be given credit for any health insurance that they are paying. And then in regard to maintenance, at this point, again, looking at the income, imputed income, the court does find there is a need of the mother as to having the additional amounts. And so we'll order the $1,500 per month commencing May 1 of 24. Neither party is to move, take, hide, damage, borrow against, etc. That will be included. Utilities, the respondent shall pay the PUD, cable, and other household bills that are in the respondent's name. Insurance, no change from the current order. Attorney's fees. The court will order the $2,500 in attorney's fees shall be paid to the respondent, Ms. Bliss. within 90 days. Restraining orders, requests will be granted. I don't know that this necessarily needs to be a part, but neither parent should be using any sort of Facebook or any other social media whatsoever to make any derogatory remarks in regard to the other parent. It's not appropriate. I understand there are things that have gone on and that emotions can get high, which is exactly why they need to stay off of the social media, keep it where it needs to be and not there. It only hurts each other, but ultimately those kinds of things hurt children, and it's not appropriate. Sounds like there was no objection regarding the birth certificates, passport, and social security cards. Is that correct, Mr. Jones?
Yeah, I'm fine.
Okay. Anything I missed?
Can I have a word, Your Honor?
What's up?
May I have a word?
I don't know who's saying that, but I'm just hearing from attorneys at this point.
No, Judge, I don't think I have any further questions. Do we want to set a presentation date?
Does July 23rd work?
That should work for me, yes.
That works for me.
Okay. All right, we'll put it on for July 23rd.
Thank you, Judge.
Thank you.
Noel McLean appearing on behalf of the petitioner Sarah Toll, and I believe Ms. Toll is also present.
Living on behalf of the state extra child support, Your Honor.
Sir, take your hat off. For all purposes, you're in court. All right, anyone else that? Okay. All right, go ahead.
Thank you very much, Your Honor. On behalf of the petitioner Sarah Toll, first, a couple of things. I would remind Mr. Williamson that he has an obligation to serve my office with all documentation that he files with the court. I would note that in reviewing Odyssey, clerk's paper 203 that was filed on filed on Wednesday, July 3rd, was not served on my office, although it appears to be a double-spaced version of his June 27th declaration. So I assume that that was in response to my client's reply objection to single-spaced documentation. I would note it continues to be over-length under the local rules. Also, clerk's paper 204, which is his financial declaration, the one that was filed with the court has additional writing as far as unknown relative to my client's income. That's different than what he served on me. So again, just a reminder that he needs to be sure to serve me with whatever he actually files with the court. I would also,
Mr. Williamson, you understand that?
I do. I'm sorry. It was just, I got served a mountain of papers and I thought I filed everything with the clerk's office, and then I emailed it to Ms. McLean per her. One of the motions said that I could email it to her. So I emailed what copies I thought I filed.
The other thing I would note is that he did file basically a reply on Wednesday. I didn't identify which clerk's paper that was, but it was 17 pages total. He also filed a proposed parenting plan, sealed financial source documents, and a financial declaration. I would be objecting to the reply declaration, as again, that's not allowed under the local court rules.
To unlock your iPhone first.
Okay, Mr. Williamson, you understand what she's talking about?
No, I don't. I filed everything last Wednesday.
Yeah, so what happens is they filed their request, that comes first, and then you do your response, and then they do their rebuttal. You don't get another time to respond.
Oh, I wasn't aware of that. I'm sorry.
Okay, that's okay. Lots of rules.
Yeah, not an attorney.
So we are before the court on my client's motion for adequate cause finding, as well as a temporary order and a referral to a guardian ad litem. We have submitted documentation, substantial documentation to the court Currently, the current parenting plan was entered back in 2016 when these children were, Kale was 6 and Olive was 5. Kale is now 14 and Olive is 12. And when you review through the parenting plan from back then, as well as the subsequent child support order that was entered in February of 2020, you'll note that there are a lot of specific provisions and micromanaging that I think speaks volumes as it relates to the interpersonal relationships between these parents. Unfortunately, the children have also been the recipient of that in regards to the struggles that they're having emotionally due to what's going on within their father's household. Kale, as the oldest child, seems to receive the brunt of the emotional abuse. And as you can see, even I had sent correspondence to Mr. Williamson over 4 years ago now, talking about the sort of the absurdity of his demands and the effects that that was having on the children. Unfortunately, Mr. Williamson's behavior has not improved, and it's continued to take a toll on these children. My client tells you of issues with, for example, visitation exchanges that were to take place in 15 minutes. And instead of him staying at the ball field and exercising the leftover 15 minutes, he drives up to his home 15 minutes away, and my client has to follow in tow in order to receive the children. I mean, these types of things have been upsetting to the children and just reinforce Mr. Williamson's argumentative nature. Unfortunately, Kale has had to seek out emotional support, not only from my client, but from the counselor at school, from a teacher at school, from his personal counselor. And you can see the letter that was filed from Mark Meadows. That's Clerk's Paper 186, filed back on June 13th of this year, where it talks about Kale's difficulties that he's been experiencing and his disclosures to his counselor during that therapeutic relationship. You can see that during multiple sessions between March and May, Kale had made many disclosures about verbal and emotional abuse by his father. Kale described feeling sad, feeling left out, instances of his father and stepmother gaslighting him, and resulting in Kale acknowledging that he wanted to run away from his father's home. This sort of culminated in this incident in May of 2024 when the kids went to father's home Friday after school, only to have Mr. Williamson bring Kale home shortly after when he got home on Friday. Kale was extremely upset. He was hyperventilating. He started sobbing after he got into the home and my client was able to calm down. And at that point, Kale revealed that his dad basically was punishing him, was not happy with his behavior, and told him he had 2 weeks to decide if he was going to remain a member of Mr. Williamson's family. That's a huge burden to put on a 14-year-old. And again, just gives a glimpse of the things that these children are enduring within Mr. Williamson's household. My client goes on to tell you about the unequal treatment that Kale feels, particularly around his education. We have a gentleman who is working hard in school. He does have some educational impediments, and he is on an IEP, and he's had long-term tutoring to assist him with his educational needs. Dad and stepmom appear to daily review what's going on, and Kale is routinely punished within his household if they perceive that he's got missing reports and the like. Even when they know that Kale has had absences due to counseling or other necessary appointments and has arrangements to make those up, you can see that overall Kale is a good student. He has a 3.467 GPA. He's made honor roll. He's in the Honor Society, and he's in the AVIDS program. And yet, when he does well, then Mr. Williamson threatens to remove his tutoring support from him. Unfortunately, this has not boded well for Kale's relationship And Olive observes this as well. You see where she was also asked after Cale had been returned home to his mother whether or not she was going to decide to be able to remain in the family. Again, very abusive and not appropriate parenting. There's other instances that we have outlined within my client's declarations, and I know it's been a long docket. You still have some other matters. I know that you've read through everything. I think the fact that Mr. Williamson has indicated to Cale that it's up to him, and then after he gets served with our documentation, decides that no, it's not up to him, I think that that speaks volumes as to his mindset. We're asking that the court enter a finding of adequate cause. We're asking the court to refer this matter to a guardian ad litem. We are asking the court to adopt our temporary parenting plan, which allows the children to determine what their residential time will be with dad. Just as a reminder to the court, I would also note that even though the existing parenting plan provides that the children can have contact with the non-residential parent, dad has blocked mom from his phone. The children are not allowed to call unless they specifically ask permission from dad. And then it's up to whether or not dad's going to honor that. And that's not the spirit of this parenting plan. So this, again, ongoing exposure to conflict is not healthy. Many studies have shown that exposure to ongoing conflict is not healthy for children. And you do have older children, these are teens, who are rebelling against dad's behavior to them. They don't want to be put in that situation. They love their father. They want to have a healthy relationship with him. But clearly you can see Cale's struggles in his disclosures to his counselor. And now that we're on summer break, we don't have the additional support of his teacher and school counselor. So we do believe that it is appropriate for temporary orders. In regards to child support and the financial requests, again, my client is asking for a contribution towards her attorney's fees, given the fact that Mr. Williamson's net income is almost 3 times her net income, and we're here because of his behavior. My client's net is $3,386 per month. We originally guessed at Mr. Williamson's net income. You can see from the financial documentation filed this last Wednesday that his income is much greater than I and my client guessed. He calculates his net income at $8,601 per month, which we would acknowledge and agree to that. With that, that would change child support to $1,685 per month, and him paying 71% of expenses. We are asking the court to include the ongoing treatment for Olive with Dr. Kai. She's been with Dr. Kai for the last 2 years. And now because Mr. Williamson believes that Dr. Kai should follow the same practices of giving a $500 deduction that one of the other orthodontists in town provides, he's withholding his approval of proceeding with the braces, even though, again, Olive's been pursuing this for the last 2 years in preparation. And Dr. Kai already provided a $250 deduction. We're also asking, again, that we maintain the tutoring. Cale needs that educational support, maintain the extracurricular activities. We're asking that the court consider adopting driver's ed, driver's permits and licenses, and automobile insurance for the children moving forward as they age appropriately.
All right, Mr. Williamson, this is your opportunity to tell me what you would like to tell me, but it needs to be information. I've read your documents. So is there anything else you want to add?
I'll just respond to the stuff that she has just said. I'm pretty sure I responded to most of it in my declaration as well. But I mean, they're bringing up the fact of the 15 minutes after a baseball game. I mean, the parenting plan states that that's their time with me. That 15 minutes is that's a large portion of my time. So if I could spend that time talking extra with my children, I don't see why that's so frowned upon and I'm made out to be this bad guy who doesn't want to cooperate. I'm just following the parenting plan. That's what I've always done. And anytime I do and she doesn't like it, here we are. I mean, she brings up the runaway Cale telling his counselor that he wanted to run away from my home, which these court filings are the first time I ever heard of that. So of course I would question Cale. I don't want him to run away. I'm going to be more vigilant while he's here if that's truly how he feels. He's never expressed that in our home. he's not treated any differently than the rest of our kids in our home. Ms. McLean says we daily review his grades. We do that with all our children. I mean, it's live. We can see their grades on a daily basis. And the only reason we do is to keep Kale caught up, because Kale is a child that if he gets too far behind, he's not going to catch up. So if we don't check it and hold him accountable, I mean, turning in his assignments is just effort. That has nothing to do with his disabilities in school. That has everything to do with his effort. So we have that rule in our home that if you have a missing assignment, that's just your effort that's lacking. That's the only thing that's a result of. So yes, we hold them accountable and we'll take their electronics away. We don't punish them. We take privileges. She refers to all these appointments for his counseling and missing assignments, but as you can see, I'm never notified of his appointments. The parenting plan says I'm supposed to be, and that's always been an issue for years. Ms. Toll makes appointments and takes him and doesn't tell me anything. So then I have to ask Kale, why did you miss school? Oh, I had an appointment. It comes from him. I've never threatened to take tutoring away from Kale. The conversation was had 2 years ago when Kale was doing very well in school. And I simply asked Ms. Toll about having a conversation if he truly needed it anymore. Obviously, he remained in it, so it wasn't taken away. I still pay it to this day. He goes once a week. And the whole Kale had a choice to come here, that was for a short amount of time when Ms. Toll herself said that she was concerned about his mental health, said he needed a break. So we said, for a while, we'll give you a choice. If you want to come, have your space. And I decided well before I was ever served with any of this, that he had enough space and it was no longer a choice. Kale needs his father too. It's just a lot of stuff that is untrue or embellished. Ms. McLean said herself, these kids are teens and they're rebelling against their father. They're rebelling because they don't like discipline. I'm trying to teach them responsibility, and I'm doing it in the best way I know how. She brings up my wage being 3 times more than Ms. Toll's. Well, that's because Ms. Toll works part-time. She provided her pay stub and she has 52 hours in a 2-week pay period. That's only 26 hours a week. So of course I make much more than her. I don't think that's fair. So I would ask the court to impute her income at full-time, because she has the ability and the means to work full-time. Our kids are in school. They're 12 and 14 years old. They're left home alone at her house all the time to go do their things. So I guess I've always followed the parenting plan. The courts can see it. Last time we were there when she thought I was in contempt, I followed the parenting plan. Our parenting plan is the order of law in regards to our time. And that's what I follow. And I just ask that you deny this whole, that the motion to show cause. There's nothing changed other than Kale doesn't want to be disciplined. That's when this all started. I'll bring up that on her Ms. Toll's financial declaration, she totals $6,169 in monthly expenses. But then in bullet point 8, showing her debts, it shows her only debt is $1,000 to a credit card. I don't know how anybody can be $3,000 in the hole every single month and not have any debt. That doesn't make sense to me. And then in her proposed parenting plan, on I, communication with the children, it touches on neither parent shall tell the child that it's a choice whether they go to their house. And that's exactly what this parenting plan does. It gives them the choice. So I don't agree with that. And then I guess that's all I've, and then attorney fees. I don't have an attorney myself because I can't afford one. I'm a father of 5 and the sole breadwinner in my home. I struggle to get by now. So putting more attorney fees on me will put me even farther in the hole. I've never disputed my child support being what the state schedule says. I now have another child. She's almost 2. And then Tucker, he turned 7 this week. I got the deviation for Tucker last time we were here. And now I'm asking that I get the deviation for Lana as well. I think that's all I got.
Else? Okay. Ms. Looney?
Thank you, Your Honor. The state would just reserve to just address child support to wait for Your Honor to make a decision on adequate cause.
Okay. All right. So I have reviewed the files and record, and the court does find adequate cause has been established based on that, based on what's been submitted. So based on that, I don't know, Ms. Looney, if you want to go ahead and address child support.
Thank you, Your Honor. I did review Ms. McLean's proposed orders. Now it appears there's some additional information regarding what support may need to be calculated at. The state's interest is only regarding medical at this time. I did see noted that we had proportional share at that time, but the percentages were just noted separately. We would just ask that if amounts change, that it continue to be a proportional share for any uninsured medical expenses. We would also ask that it be noted that the children are currently on state medical through the mother, and that would be the only request the state would ask.
All right, so going on then, one of the big things that I just see, and I've seen it more and more, is the use of social media to have their say in regard to the other party or spouse, whatever it may be, but neither party or neither parent or anyone else, meaning a spouse or significant other, is to discuss this case with the children. That includes no posting on social media. It's not appropriate. Just leave it where it needs to be in the courts and keep it off of social media. Mr. Williamson, as to affidavits, I don't think I talked about this yet, but one of the things when you do it, your statements, single space, that's not appropriate for the, when we talk about or have the rules about the length of affidavits. So you should use 1.5 for your spacing, just so you know that. So as to the parenting plan and requests there, the current parenting plan is to remain in place pending an investigation by a guardian ad litem. So who were the next 3 guardian ad litems?
We have Karen Lawrence, Amy Turnbull, and Ann Height.
I would strike Lauren.
Okay. So Mr. Williamson, that leaves Amy Turnbull or Ann Height. I don't know if.
Ann Height, I guess. I don't know either one of them.
Okay, so that would be Amy Turnbull would be the guardian ad litem.
I have provided the court with a GAL appointment order. You just need to interlineate Ms. Turnbull's name at paragraph 3 on page 1.
So Mr. Williamson, I have an order appointing guardian ad litem for a child. And so I'm just inserting in that the name Amy Turnbull. You can go on our court website and get the contact information for Ms. Turnbull, and you should reach out to her and let her know that she was appointed. Okay. And I will be making this, it has 34% paid by the petitioner, 66% paid by respondent. So basically based on the incomes. So with that, are you okay to put approved via Zoom on this for your signature?
I'm sure.
Okay.
Your Honor, I also note at the top of page 3, I set a 30-day GAL review on August 20th at 9 a.m.
We'll be gone, right? I'll be out of town August 20th.
Hold on just a second. Okay, what about
I could do the 27th if that's acceptable.
Mr.
Yeah,
Williamson, does that work?
Yes.
Ms. Looney, does that work?
Yes, Your Honor.
Okay, I've changed that to August 27th.
And then I set a final GAL review of November 26th.
Okay.
Did the court want an interim review?
At this point, I don't think so. I'm just going to leave it where it's at. If it needs to be noted on, it can be noted on.
Okay.
All right, so I've signed off on that order. All right, then in regard to the child support modification, there will be a modification with the net, the father being 8,601. In regard to the mother, is the court agrees that if the mother has the ability to be working full time, then her income needs to be imputed to the full-time wage.
And I think that her overall, let me just check my calculations real quick. I used her gross of the $4,787.
Okay.
And I thought that she worked 32 hours a week with her position with Kaiser. So I don't know if the
She
most
does,
recent,
and I'll leave it alone.
I see that she has, let me just run that real quick.
And then the father should be given credit for his children.
Okay. And we had asked that the court not deviate given the lack of housing expense.
I do have a housing expense.
So I want at least one child for the deviation.
Okay. And just so the court knows, on her gross income, that's an average of 36 hours a week.
Okay. All right, then that should be okay.
All right.
And then not quite sure how this works, and maybe Miss Looney can tell me if she has state insurance, she doesn't pay for that, correct?
That's correct, Your Honor.
Okay, so no cost
Right.
there.
And my understanding was that she does cover the children on her Kaiser insurance, but that there's no expense. She doesn't pay extra to cover the children.
Okay. And then the father, if he shows proof of coverage, then that should be calculated in. And then the driver's education fees or costs are to be included when appropriate. And as to the braces, daughters to obtain braces at doctors she has been seeing.
She's never had braces, Your Honor.
She has a dentist that I understand can do the work. Maybe I'm wrong on that. Is that correct, Ms. McLean?
My understanding is that she's been doing preparatory work with Dr. Kai. I'm assuming that that includes like banding and whatnot that would be precursors to braces. But she's been an active patient of Dr. Kai, who's an orthodontist here in town for the last 2 years, from my understanding.
Okay, if that's the case, then she can just stay with that doctor. I'm not going to move her. So, and then attorney's fees, that issue will be reserved at this time until further consideration of the parenting plan modification. So I'm not ordering any attorney's fees.
Okay. So does the court want to set up a presentation on so the court's not entering the parenting plan. So do you want to do a presentation on the updated temporary order and the child support documentation, maybe on August 6th?
I will not be here on August 6th or August 13th. I can do it August 20th.
And I think Mr. Williamson.
I think Mr. Williamson wasn't available.
So you just want to do the 27th then with the GAL?
Yeah, we'll just do the same day.
Okay.
So Mr. Williamson, you may know this already, but basically Ms. McLean will prepare orders that reflect my ruling. And if you accept that's what they say, then you can sign off on that. If not, then we'll see you back here on August 27th for the guardian ad litem matter, as well as the presentation of orders, and we can go through them at that time. Okay.
Can I make the request that child support order is not backdated, that it'll be active that day? I've been down that road, and it's a hassle to try to get it all caught up with the state, because the state just takes the money out of my check up front, and if it's backdated, I'll already be behind.
So it is, I actually didn't state that. It should be commencing July 1.
Okay.
And so did the court sign the adequate cause order that you have before you?
I do have the adequate cause order.
Okay. So both the adequate cause order and the GAL appointment order I'll provide to Mr. Williamson and Ms. Looney once those are available on Odyssey.
Okay, so Mr. Williamson, are you okay to put approved via Zoom on that order as well? It doesn't mean that you agree with it. It just means that it reflects what I ordered.
Yes.
Okay. All right, I've signed those 2 orders. Ms. McLean said she'll get you copies of those. And then otherwise, we'll see you back here on August 27th.
Okay.
Thank you.
Thank you, Your Honor.
Thank you. So council, I have the proposed orders from Ms. McLean with the objections of Ms. Baldwin. And then I have,
Your Honor, I don't know if we have Ms. McLean back.
what's that?
I don't know if we have Ms. McLean. Oh, there
I'm
she is.
here.
Oh,
here.
I'm sorry. Thank you.
No, that's okay. That's okay.
And then I have proposed orders from Ms. Baldwin. And let's see. All right. So here's what I've tried to figure out as far as how to do this. I found that Ms. Baldwin's objections seem to be an overall type thing, and then I had the proposed orders from Ms. Baldwin. Quite honestly, I found Ms. Baldwin's orders, proposed orders, to be more reflective and clear as to what the court had ordered. However, Ms. McLean has not had an opportunity to do responsive objections to those orders. So that's where I'm at this point of the best way to proceed. So counsel, I'll defer to you at the moment as to what your thoughts are.
Well, I don't mind. We can set over to that alternate date like we have in some of the other cases. Ms. McLean can make her objections to I only proposed 3 orders that had the most changes. And so I was fine with her child support worksheet. And then there was just a few changes in the other orders. So that would give Ms. McLean an opportunity to make objections just as to those 3 orders.
Ms. McLean?
Whatever the court wants us to do, if you want me to go through as far as my responses to counsel's objections to my proposed orders, as well as my objections to her proposed orders, I can do that. Or if you want me to submit my objections and counter arguments to Ms. Baldwin's objections, I can do that. I am scheduled to be out of the office the 12th through the 31st of July. So although I'm back in court, I'm coming back off of vacation next Tuesday for a finalization matter before Commissioner Carmi at 1 o'clock.
Oh, at 1 though. I'm available next week. I just don't know Ms. McLean's availability.
So looking at the Thursday, which I had thought we'd set it on a Thursday, but apparently, obviously not.
We did, and then the court's investigator said she wasn't available on the 22nd, and so then I think that's kind of where wires got crossed, as I believe she asked to not have it set on the 22nd because she's out of town. If Your Honor wants her to be present.
Right. So I would like to see Ms. McLean respond to Ms. Baldwin's orders so I can see what the issues are that Ms. McLean has.
And then perhaps, as the local rules suggest, then the court could maybe just work through them and just submit what you think is appropriate, or do you want us to note it up for additional argument?
And I think that's fine, Ms. Baldwin.
That's fine.
Yeah, I think that's fine. I think that will work better. And then with the conflicts, as far as dates and that, because I am gone the first couple weeks in August. So we wouldn't be looking at these again till probably the end of that month. And so I think that would be the better thing, is go ahead and have you do written responses. Let me just use that, and I'll do the how they should be modified, if anything.
And then can we clarify, since originally I think we were talking about having the review for the investigator on August 22nd, but my understanding is she's not available. Do we want to reset that now? Since we're all—
I thought we already had.
I just want to clarify because there was so many dates, then I want to clarify when it was set for.
I have it at 2 p.m.
It was reset for, let's see.
Yeah,
Oh, I have it set for Thursday, the 22nd.
yeah, it needs to be reset to the 29th.
Okay. That's fine.
All right.
Okay.
So
why doesn't Your Honor in the temporary order maybe just make that like a clerk's action and just add that in, and then that can clarify that, and the clerk can strike the 22nd.
Okay. So go ahead and get me your objections, Ms. McLean. We'll get it on for the 29th rather than the 22nd, and we'll go from there.
That's still at 2 p.m. on the 29th?
Correct.
Okay. All right. I'm going to try and get them my objections and stuff, or my responses out by this Thursday. But if not, I'll get them to you by Tuesday for sure.
Okay.
Okay.
All right.
Thank you.
Thank you.
Thank you.
That concludes this docket.